Welcome, everyone, and thank you for joining us for May's Family Law Academy. My name is Allison Frazier, and I will be talking with Sodoma Law attorney Theresa Viera about what to expect when expecting to divorce. To give you a little background about us before we get started, Sodoma Law is a family-focused and family-driven law firm with practice areas in family law, business litigation, employment law, and estates, wills, and trusts, serving both North and South Carolina. If you have any questions during the presentation, please type them in the chat box to the right of your screen. We will also have time for questions at the end. Also, we love social media interaction. Feel free to interact with us live at Sodoma Law on Twitter or by using the hashtag #TheSodomaWay. If your question isn't answered today, please feel free to follow up with us directly after the webinar. We always love to hear from the community. You may know that I'm not an attorney, so they've brought me in for this specifically to talk about the things that you should expect when you're expecting to divorce. I'm also unmarried, so I'm a good guinea pig test candidate for this conversation. So Theresa, I think the first thing we should talk about is what should we know? Let's discuss preparing to meet with your attorney that initial time. Right out of the gate, you're looking for someone. You're going through this tumultuous time in your life. What should people know about preparing to meet with their attorney for the first time?
Well, let me first state, if you're planning to meet with an attorney, it means your life is probably in some type of chaos. And wherever there's chaos, there breeds disorganization. So let me tell you now, and this is probably a life skill that we should have even before we expect chaos to ensue in our lives, and that is organization. Keeping everything organized in your life is probably rule number one. For example, if you have monthly expenses and bills, which I think that's pretty much everyone, then you should probably have a budget and keep those bills and monthly expenses organized. And then when you're meeting with an attorney, then you can just print out whatever your budget or your monthly bills are and you can present them to the attorney at that first meeting. Especially if you are deciding to separate and haven't separated yet. You're going to go from a possibly 2-income, 1 household to a 2-income, 2 household situation, or possibly even further, a 1-income, 1 household, 1-income, 2 household situation. So knowing what your numbers are from the get-go and knowing how your budget and your bills are organized immediately, even before you meet with your attorney, is key. Thereafter, make sure you realize that attorneys don't work for free. So you are going to want to organize your finances in such a way that you are ready to actually move forward with not only absorbing the legal advice that an attorney provides, but also paying the attorney's fees bill, which sometimes we don't really want to talk about.
And on that note, being organized, I guess, can really help you keep those fees down. The longer an attorney has to wait or the more things they have to dig through, the more time it takes. And they're paralegal included.
That's correct.
So the more organized you are, really, the more it helps you out in the long term. The other thing we talked about was setting some deadlines. Let's talk about that. Let's talk about what kind of deadlines that you set as an attorney and how you go about setting expectations. I feel like setting expectations is a really important part of the process. So let's talk about some of those expectations.
Well, the very first deadline is when you're first meeting with the attorney. So if you have an appointment scheduled, your very first line is making sure you have everything in order before you even meet with the attorney in that initial consultation. Thereafter, the deadlines really depend on your case. For example, if a lawsuit has already been filed, there are already defined deadlines. You may not know about them, but they do exist. For example, when a complaint is filed against someone, as soon as that person receives the complaint, they have 30 days to respond. It's in very small print on the very first page, and a lot of people miss it, but you are required to respond. Now, there are ways to file extensions. There are ways to get around those deadlines, but you may not know about them, and it can be used against you if you don't realize those deadlines up front. In addition to that, there are other processes along the way. For example, there are certain affidavits that need to be filed. There are certain other deadlines that will come about, such as initial pretrial conferences and final pretrial conferences. All of those deadlines require certain paperwork, possibly even affidavits that need to be filed. So your attorney might tell you a certain deadline, And that's a deadline before the attorney's deadline is due. So for example, if something is due at the end of the month, I will generally tell my client that they need to get documents to me and the information to me no later than the 15th of the month. And if my client doesn't get it to me by the 15th of the month, and rather I get the documents, say, on the 25th, then I literally have maybe a day or two to coordinate everything. And honestly, that usually means I'm working late. And if I'm working late, that means attorney's fees usually even bump up further.
Right. So, well, and that also goes back into being organized, and also the fine print. All of these reasons are just one more reason to hire an attorney, right?
That's true.
All of these things that you don't know, like to look for the 30 days, all of the things, these are things that your attorneys are trained to know. These are things, I like to phrase it as help us help you.
Exactly.
Right?
Yep.
The more we know and the more in advance we get the information, it seems like the better it is for your attorney. It seems like your attorney can really take the reins at that point.
It's very
true. Something we've kind of touched on twice now that is always the burning question that we get is, let's talk about hourly rates. That's what people want to know, right? I feel like the number one question we get is, well, how much is this going to cost me?
Exactly.
The answer to that question is it depends. So we're going to talk about why it depends right now.
And I actually, Allie, I hate that response. It depends. But it's true. And in the legal world, it really does depend, because your family situation is so unique. Similar to how two people never have the same wedding, two people are never going to have the same divorce or divorce process. Let's talk a little bit more about hourly rates in general. So the hourly rates I generally see with attorneys range anywhere from $150 per hour upwards to $600 plus per hour. Those rates generally depend on the years of practice that attorney has actually been practicing law, as well as the level of experience of that attorney. Now, let me note though, there's a difference between level of experience and years of practice. For example, in family law, we spend a lot of time in court, unfortunately. However, there are attorneys out there that state that they have 10 years experience of being an attorney, but they may only have 1 or 2 years experience in family law. And so they may not actually have exercised any of their 10 years in a courtroom. Most attorneys actually do not practice law in a courtroom. So would you rather someone who's never practiced in a courtroom, although they have 10 years experience, or would you rather the attorney who, yes, has been practicing for 4 years, but 3.5 years have been in the courtroom, knowing what happens day in and day out in the court process? That's one thing to consider. In addition to that, there's also the level of support. So generally, an attorney at a law firm, you're not only going to get their legal experience and their legal skill working on your case, you're going to get the legal skill and experience of the rest of the attorneys at that law firm. So keep that in mind, that when you hire a firm, you're not only hiring the attorney, you're hiring a body of expertise that's on your case.
True. Now, there are things such as flat fee divorces, correct? Or quick divorces. I don't know if there's a such thing as a quickie divorce, but flat fee divorces. Let's talk a little bit about that and how people can utilize that.
So that's a very good question, Allie. And unfortunately, I always have the heartbreaking news to tell my clients there's really no such thing as a quickie divorce. Now, there is the process here in North Carolina known as the absolute divorce process. That absolute divorce process is a relatively short process, but let me state this. Generally, that process is at a minimum about 2 to 3 months. When I tell my clients that, they're usually like, 2 months, Theresa? That's not a short time period. Well, in our world, it really is, because some cases can last years. With that stated, the absolute divorce here in North Carolina does not address all of the concerns that actually arise with a separation and a divorce. For example, did you have children? Child custody and child support are not addressed in an absolute divorce claim. Do you have property? Do you have any debt? Those issues aren't addressed in absolute divorce either. And then, of course, if you have a spousal support claim, and generally this is where someone is a dependent spouse and substantially dependent, i.e. they could not actually go out on their own and support themselves because either they have no income or a very, very low income as compared to their spouse who's been supporting them through the marriage. And that is another claim that is not addressed by the absolute divorce. So I always caution people, if you see the billboards or the ads that say, oh, for $300 I can get you divorced, it's very possible that you can get divorced, but you're not going to divide your assets, you're not going to get alimony, you're not going to deal with a parenting arrangement, and you might not get child support. So you have to be careful. In addition to that, let me also add here, there's a difference between attorney's fees as well as court costs and court fees. By law, attorneys are not supposed to pay for them, and therefore sometimes when you see the quickie divorce for $300, that does not include the $225 filing fee for the absolute divorce, for the divorce. So that means
it's not $300.
Exactly. It's not even close to $300. And in fact, depending on the other filing fees, it could be a lot more.
Absolutely. Okay, so we've kind of covered the basics. We've talked about the importance of vetting your attorney, making sure you find an attorney that's a good fit for you and for your case. We've talked about getting organized. We've talked about the hourly rates. So now let's talk about what happens once you found your dream attorney, you've retained him or her, you're getting ready. And as Theresa said, you know, these quick divorces, they don't just cover that. So in North Carolina, what other matters do you have to prepare for in the divorce process? And what other types of things, once this case gets started, should clients be looking for, or should be prepared for?
Should be concerned about. Let me first point out, when you are looking for an attorney, to find that dream attorney, I always tell my clients, finding an attorney is like finding a pair of shoes. Just because a shoe is in your size does not mean it fits comfortably. And trust me, there are enough attorneys in your area or town to know that you may not fit with one attorney. If you go with another attorney, that's quite all right. You want to find the best attorney for your family situation. Now, with that noted, that attorney should also be knowledgeable about those other matters that come about. For example, which we touched on briefly a moment ago, if you do have marital property, or if you do have marital debts, more specifically, say if you have a marital business, you do want to know how the law applies to that situation. The claim here in North Carolina is called equitable distribution. And essentially, 9 times out of 10, that means that the assets and the debts will be divided equally between the parties. Now, of course, if you only have a house, equally doesn't mean taking a chainsaw and dividing it 50-50 physically.
No?
Even though I've seen that.
Okay.
I've seen that in the news.
That's a story for another day.
But rather, what the court will look at is look at the equity in the house. And if one party is keeping the house, they'll buy out the other party. Or if the parties choose to sell the house, they'll divide the proceeds equally 50-50. And this is in addition to financial support, spousal support for the spouse, child support for the child. Those are 2 additional claims, as well as child custody. Now, let me note, and people often forget this, child custody and child support really, the claims themselves don't actually have a relationship to the divorce process.
Interesting.
Reason why is people can have children out of wedlock. People always forget this.
Yes.
So the divorce process is actually not tied necessarily to the child custody and child support claims. So keep that in mind when you're actually thinking about your divorce. Child custody and child support actually isn't part of your divorce.
Interesting. Okay, so let's talk about time frames, because like you were saying about the quickie divorce, I feel like a lot of times people think, well, I'm going to go in and we're going to get this taken care of. We're kind of a little bit at the mercy of the court system, of course, but what kind of time frames should people expect? You know, do you 6 months, 3 years? It depends.
And I hate that I'm saying this, but it does. It depends. It depends. Now, let me first say, for the individuals who haven't separated yet, the process itself doesn't actually start until the date of separation occurs. And the date of separation is when the spouses reside under separate roofs and at least one party has the intent to end the marriage. So that's the first step in the process. Now, before we can file the absolute divorce, this is the clearly delineated deadline, but before you can file the absolute divorce, 1 year has to pass from the date of separation before a complaint for the absolute divorce can be filed. However, that 1 year period is the time period to address those other claims we were addressing earlier: property, financial support, and child custody arrangements.
I was just going to ask that. So if you have to be separated for a year, you can go ahead and start working towards those things so that when the year hits, you're ready to move forward,
You
right?
actually want to do it before the year has even ended. Because I will note, if a divorce judgment is entered, your right to actually ask the courts for help in property distribution, debt distribution, and spousal support cases diminishes. In fact, in most cases, once a divorce judgment has been entered, you no longer can bring a claim for equitable distribution or spousal support. There are exceptions, like there are exceptions to every exception, but that's the general rule. So you actually want to start thinking about these matters at the date of separation, even prior. Now, with those deadlines in mind, you can actually start the negotiations regarding what happens to your children and your property and your financial situation even before you separate. Hopefully, if you are able to have an amicable separation, you can talk with your soon-to-be ex-spouse and delve into these matters. And essentially, I would get involved only to make your agreement legally enforceable. I would not be involved to start mudslinging because hopefully you're amicable.
Exactly. Well, and it's Sodoma Law, we've handled everything from high conflict divorces to collaborative divorces and mediation. And, we have attorneys on staff that specialize in all of that. So it really seems like, again, this goes back to finding the perfect fit. Deadlines, and being organized. Okay, so now let's talk about identifying your future financial and property needs. As someone, and I'm ashamed to admit this, but even I don't think that I'm probably in power of my financial future as I should be. Things like 401ks and
IRAs.
Oh gosh. So let's talk about, and it's just me. I only have me to worry about. So then what happens in the event of a divorce, especially sometimes one spouse has maintained most of that. Now all of it has to be split. You have to learn, how's the best way? How do you advise clients to deal with that?
It's really hard, especially for my clients that don't really have a hand in handling the day-to-day financial operations of their households, even when they're on their own. And so the very first consideration is to take control, is to first off figure out, okay, which banks do I have bank accounts in? Which investments do I have? Which jobs have a 401k set up for me that I might have left a few years ago and I completely forgot about? Those are all considerations that you want to take into account as soon as you start going through the process of separation. Let me state, for equitable distribution purposes, anything created or actively gained during the marriage, which I can go into further detail later, is marital property subject to distribution. So even if the IRA and all of the investments, they are in your spouse's name, technically they are still subject to a 50-50 distribution. I like to tell my clients, it doesn't matter whose name is on the title, it's marital property and it's still subject to distribution.
And if you have any questions about that, you can always reach out to us. And we also have some great information on the website. That's probably something we'll revisit a little bit later in the year in one of these, because it does have a lot of nuances, which is really interesting. Okay, last but certainly not least, as a law firm that really focuses on putting families first and including in those families, most importantly, is the children. Children are affected by divorce. There are studies that show it. It's one reason that we really like mediation and we really like collaborative divorce, and we really like being able to focus on the kids and focus on what's best for the family, right? Because we want to build the best future for our clients and for their kids. So we're getting ready to talk about what happens if you have kids and you divorce. What happens?
Yeah. Well, let me first state, Allie, I actually don't like to call myself a divorce attorney. I actually hate that word.
Marital attorney?
No. I actually like to think of myself as someone who helps people in unhealthy situations move toward a healthy situation. That is what I do. We identify the unhealthy factors and move to a healthy situation.
We're family law attorneys.
Exactly. So we're trying to keep this family together. We're trying to keep you and your children healthy.
Yes.
So the first thing I want to point out is when you're going through a separation, when you're going through the divorce process, you are experiencing a form of grief. Some studies have shown that this grief is similar to if you were to lose a loved one. And it's so extreme of a type of grief that there are, and granted, I'm not a scientist or a medical doctor, but apparently there are literally chemicals in your brain that do not permit you to actually think straight. So you cannot think straight when you're actually going through a divorce. So
your emotions,
your grief,
emotions get in the way.
They do. And so one of the best factors of having an attorney involved is that attorney can remove the emotions from the situation and help you realize what your rights really are. I'll give a perfect example. Many fathers believe that they don't have rights to their children. Many fathers believe that if they go to a courtroom, they're just going to get some time on a Saturday, maybe every other Saturday. And honestly, sometimes they'll go ahead and sign a document, a parenting arrangement that only gives them that amount of time. And of course, then by the time I get involved, I'm like, no, you shouldn't have signed that. Oh my goodness.
You should have consulted an attorney before you signed that. Okay.
The grief and the pain associated with the separation, especially because regardless of the animosity between spouses, both parties do feel a certain amount of guilt. And that's okay. But with that stated, you don't want that guilt and those emotions to cloud your judgment such so that you actually lose your legal rights. So when it comes to children will be spending time with both parents. How much time? It really depends on your circumstance. Of course, if one parent works overnight, 5 overnights per week, then they might not have the children 5 overnights per week. However, taking into account each particular family situation, a parenting schedule will be developed. Each parent will have time. And then it's really up to you how you then design your family. Do you want to mudsling every time the child has a soccer game? Or do you want to work together? Do you want to split the expenses regarding the soccer shoes? Or do you want one party to pay for those expenses in full?
And so really what it sounds like is, it is an emotional time, and hiring an attorney is hiring an objective party who is going to look out for your best interest and those of your children. Also, at Sodoma Law, we also have parenting coordinators. Parenting coordinators are actually a totally separate, correct me if I'm wrong, totally separate entity from either party's attorney. And their job is to work with the parents for the best interest of the kids.
So parenting coordinating essentially was developed because the state legislature realized that the courts were being inundated with a lot of claims that had to do with decisions that judges really didn't want to decide. For example, whether or not the child's hair should get cut, or more importantly, who should be the doctor for the child, or which school should the child go to. And I'll be honest, judges in pretty much every county in North Carolina do not have the resources or the time to research the available options in terms of schools and doctors and other important decisions. So the state legislature literally passed a law that gave power to what we call our parenting coordinators. And a parenting coordinator can be appointed in a high conflict custody case to get involved as an unbiased party, to listen to both sides in regards to parenting decisions and help the parties either meet in the middle, or if they literally just cannot agree on a decision, then the parenting coordinator is given the power to make the final decision. A perfect example is, let's say mom wants school A and dad wants school B. The parenting coordinator will first listen to the reasons of both parties, go into the conversation, understand the situation. But if the parents are still not able to agree, then the parenting coordinator, as an unbiased and removing themselves from the emotion of the situation, will actually sit down and say, okay, well, school A has a certain student to teacher ratio, has certain passing rates, same as school B, and then they'll compare. And whichever one objectively is the best school for the children will be chosen by the parenting coordinator.
So what is the difference between a parenting coordinator and a guardian ad litem? Yes, nailed it. These words are no joke. I guess I should say again, one more reason to hire an attorney. They also help with kids in the event of a divorce, correct?
So let me first back up.
Okay.
So the word guardian ad litem has actually been used in many different ways.
Okay.
So the guardian ad litem itself, there was a recent ethics opinion that differentiated a guardian ad litem from a best interest attorney. So a guardian ad litem is basically anyone, doesn't even have to be an attorney, who tries to represent what is beneficial for a child's situation. A best interest attorney, however, is actually an attorney that generally is appointed by the court or by the consent of both parties to represent the legal interests of the children and to stand in as a representative to the court to identify what the best interest for that child is. Now, that's completely different than a parenting coordinator, because a parenting coordinator is essentially someone who is not a representative of the child, but rather a mediator or a go-between between the parents.
Right.
So yes, there are times that the parenting coordinator can talk to both the parents, the children, and any other third parties that may interact with the children. But the parent coordinator is not there to be a representative to the court necessarily.
So what we're really saying is you have a lot of options. And the most important thing to do is explore and to research them, because there's help out there for everyone. Regardless of your situation, there is someone out there that can help you resolve it. I can't think of anything else. Is there anything that we're missing? Is there any last words of wisdom that you would want to share with someone?
Well, what I would state most of all is don't attempt to make life-changing decisions alone. No one can achieve any form of success or closure or development or any form of growth alone. So hire the team that fits your situation.
Absolutely. Well, it looks like we've covered everything on our topic today. Before we wrap up, I just want to remind everyone that these are a monthly webinar. You can go on our website and see what the upcoming topics are. You can subscribe to our YouTube channel. And last but certainly not least, thank you, Theresa, for joining us today. This is very informative. It was informative for me, and we hope it was informative for all of you. This will be on our YouTube channel, and it will also be housed on the website after the fact. So we hope you all have a fantastic rest of your week, and thank you for joining us today.
See you later.